Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Well, there's a lot of buzz about the appeal of DHSS's loss in the Court of Appeals regarding discovery of medical marijuana facility license application answer content. As most of you, well, many of you may be aware, DHSS is arguing that that's confidential information required to be kept confidential under the Missouri Constitution. However, the administrative court said no, the Court of Appeals said no, and now DHSS has applied for transfer to the Missouri Supreme Court. The question is going to be, what happens now? Well, first, the Supreme Court will either decide to take the case or they won't. There are some people that seem to be under the impression that they won't, because the opinion in the judgment underlying in the Court of Appeals was quite thorough and very well done. And it was. But that's not the end-all be-all. I mean, the court may still take it. It does inculcate a constitutional question and a Missouri state agency question, and several aspects of Missouri law. So in this case, there's a reasonable line of thought that says the Supreme Court will take and hear this case. However, there are also very valid arguments that they won't. So we can get into speculation on that. But let's talk about what the transfer application and what the DHSS is arguing. They don't have any new arguments. They're just essentially arguing that the lower courts, Court of Appeals and lower court, have misunderstood or misapplied the law, and they want the case to go back. So here's the deal. Their argument is the same. Essentially, it's no, we really mean it. And it was never a good argument in the first place. So if the court hears it, I mean, you're a fool if you claim you know what the Supreme Court's going to do, or the Missouri Supreme Court is going to do. But I think it's a fair estimate they're probably not going to overturn the Court of Appeals in this, if they hear the case. That said, who knows? The bigger question is, what is happening to all of the appeals while they're waiting on discovery that DHSS is playing hot the ball with? Well, most of those are languishing. It's kind of like any agency, you know, delay, deny, hope you die. That was the VA's motto for a while. Not the official motto, but that's what veterans thought it was. Delay your claim, deny your claim, and hope you die before you can fight your claim. In this case, there's every reason to believe that DHSS is fighting a delaying game. You've all heard the phrase, justice delayed is justice denied. Well, there's a certain truth to that, but it's not a complete truth. If they delay, what they're in part hoping is that some of the applicants are going to run out of money. Circumstances will have changed. Investors will have moved on to other investments. Some of those applicants are in fact going to run out of money on their appeals. So they may not be able to continue the fight. You can probably attribute a good 20% of the denied applicants either terminating appeals or failure to file an appeal in the first place as being financial. realistically, and look, there's no basis for that 20% number. That is a wag, a wild-ass guess. But call it an informed hypothesis. I don't know. So, number of those never filed or are not continuing with it for financial reasons across the top. You know that. Now, by delaying, they're hoping they can delay it out and introduce another change. Other people that are going to run out of funds or change in circumstances that makes it no longer feasible to continue. The problem is that you still have more than 700 cases that are ongoing. What will that mean to the medical marijuana program in the future? Well, they cannot issue a license to those 700 and have any credibility left in the department for not issuing licenses in the first place. So I think we're beyond credibility of the department at this point. The question is how do they handle it? If they are going to issue licenses to those 700, say 300 of them win their case. They can't have 300 have a license without opening up to any applicant that meets the minimum criteria. I'm going to guess there's probably a number of the people who appealed, again, this always happens, that don't meet the minimum criteria. Then what happens with the licenses that have already been issued and not acted upon? Okay? You get a conditional license according to the law. You don't get the full license. Once you have the conditional license, you have to complete your build out, hire your staff, get everything in place, and then pass an inspection. Compliance check. If you make it through compliance, then you'll receive your full license. You only have 1 year, according to the regs and law, to do that. However, DHSS has granted a number of extensions to that, but not the same number of extensions as the same number of applicants who have failed to complete their licensing requirements. So, there are licenses out there that should have expired and been returned. We don't have all of that information. We'd like to have that information, but apparently it's confidential. Who knew? So, DHSS has notified some that if they don't file for an extension or get their compliance checked, that they're going to forfeit their license too. This is an entire another round of litigation. Because after that, what happens? Is that license now up for a new licensing period? Do they schedule a new licensing period and receive applications for those limited licenses? Or are those limited licenses only going to be available to the people who are appealing the denials? If that's the case, that isn't covered in law and may be subject to litigation. Because if you are an applicant, you've got your application package ready to go, you're ready for them to reopen the application licensing, but then they're giving favoritism to somebody who failed the previous round of licensing, that doesn't give you a competitive basis. So there's going to be there will be litigation over that. That will happen. The next question is, what about the people that want to sell their license? Okay, it's been a year. Offering your license for sale to someone else, selling your business, is now authorized under the law. So, if you want to sell your license, what happens? Are you going to be able to? Well, there are some attorneys, and I've had some extensive conversations with some of them, who believe that no, you shouldn't be allowed to sell your license while there are people that are on the denial list, that are in the appellate process. I don't know that I agree with that. I think that that would be taking away a right that you have under the law. And have every opportunity, and you should have every opportunity, to market your business and get the highest profit for it. Not be stuck handing it to the next guy who wasn't successful. So I disagree with those attorneys, but they make it a good argument. I mean, it's not a baseless argument. So what happens there? We don't know. It is likely going to be the subject of litigation. There's going to be a lot of litigation left in medical marijuana in Missouri. So, why do we have so many problems? Because medical marijuana and marijuana are political questions, not legal questions. The legality of marijuana is a political question. If you want to fix it, and you want it to be legal, you have to fix that politically. That requires you to write, don't call, write your congressmen, write your senators. Supposedly, the Democrats have been wanting to push for legalization. Supposedly, the Democrats control the House of Representatives. Supposedly, Republicans and Democrats have all said, in Senate, have all said that they support legalization. Yet, we have yet to see the bill come through. You know, so why not? Well, because they don't truly support, or they're hearing from one side and not the other. They're making a decision, man. Who am I going to piss off more? Am I going to piss off this group of constituents by voting to legalize? Or am I going to piss off this group of constituents by not voting to legalize? Which group is bigger and more influential? That's the calculus that's happening. And quite frankly, if you have a problem with that, that's our political system. Get involved, get active, start talking to them. Okay? I don't care where you are on the subject of guns, whether you're pro-gun, pro-2A, anti-2A, gun control, no matter what it is you want to say, the fact of the matter is that the anti-gun groups and the pro-gun groups have banded together, they've built a base, they've fundraised, and they are in there attempting to influence politicians. That's what you have to do on the marijuana legalization side. You got to get together, you have to pool your funds and your influence, and influence your politicians. Because look, senators aren't just taking a visit from any Joe Blow off the street to talk about a policy issue like that. They're a little busy. But if you go and you set up a meet with a senator that you've donated $100,000 to, well, you've got a better chance of getting in the door. That's reality. If you are going to have a meet with a senator and you are a lobbyist for an organization with 3 million members, you got a better chance of getting in the door. That's reality. It sucks, but that's reality. So, that's what you got to do. It's a political question. Handle it politically. All lawyers can do is clean up and try and find a way through the morass of law. If you want the law changed, which is what has to happen, you've got to do it politically. So, that's where we're at. That's my thoughts for this trip. Get active. Contact your congressmen. Contact your senators. Contact your state reps and your state senators. You know, it's time to get serious about it. Please hit like, subscribe, and I'll be talking to you again soon.